All right. Good morning, everyone. Very excited to participate in this amazing conference and to be able to present on an interesting topic. I hope for all of you. My name is Jonathan Cantarero. I currently serve as the director of the Legal Navigator Program at La Cosecha Community Center out in Long Island, New York. And I'm here today to talk to you about the ethics of civil commitment. My own interest in the mental health field started way back in my college days, working in special education at a public high school, and then in law school, working with government and nonprofit organizations who represented individuals who were facing civil commitment and also provided support services for individuals who had been civilly confined and were looking to reintegrate themselves back into the community. And so a lot of what I'll be talking about sort of reflects my experiences in those spaces. And, I just want to clarify, right from the beginning, what we're talking about today is understanding the ethics of involuntary civil commitment. So there's a distinction in all 50 states between voluntarily agreeing to go to a psychiatric institution and involuntary confinement that usually requires a petition from police officer, peace officer, judge, or perhaps a medical professional. I think that distinction is pretty important. Not too long ago, my community center served a family. There was a young lady who had been the victim of a crime, experienced trauma, and in discussing the crime with a medical treatment provider, had expressed that she wanted to hurt herself. And so the medical provider gave her two options. You can voluntarily agree to undergo a psychiatric watch, or we can petition to have you involuntarily confined for a few days for observation. And in that particular case, she agreed to voluntary commitment, but oftentimes, the decision isn't so black and white. And so I just want to make that distinction right from the beginning. So a little bit of a roadmap of what I want to talk about today. Three basic sections. I just wanted to outline for you a little bit of the history of civil commitment in the United States, then talk about the state's power, where they get their power to deprive someone of their liberty in this way. And then third, the real meat of this presentation is discussing the ethical foundation that allows the state to deprive someone of their liberty by civilly confining them in an institution. So very quickly, the history of civil confinement in the United States can be really broken up into three different sections. Early on in the 17th and 18th century, mental health really didn't exist as an independent field. Psychology and psychiatry were not discrete practice areas. There was no such thing as a psychiatric institution, an asylum, a mental ward, a psychiatric unit of a hospital. There was no treatment, right? There was no medical treatment. There were no prescription drugs. There was no outpatient. There was nothing. So even though there were clearly individuals who today we would be able to identify as someone suffering from a mental illness, there was really no support systems for them in place for decades. And so what ended up happening was one of two things. In some cases, the family dealt with the mental health issues of a particular family member, and they were essentially confined to the home. In other cases, maybe they didn't have any family members to support them. And, when they were in the public square, they would, demonstrate idiosyncratic behaviors. What would happen in those instances is they would just get locked up and thrown in jail. So you'll see, for example, in New York, there was a law in the books in 1788, which allowed for someone who was exhibiting lunacy or who had gone mad to be locked up in a jail and, if necessary, put in chains. So this is the situation that we had in the 17th and 18th centuries. Individuals who were mentally ill and exhibited some abnormal behavior that was threatening to others, they were either kept in the home or they were jailed. You fast forward into the 18th, I should say 19th, and the mid part of the 20th century, and things go in the completely opposite direction. You have advancements in medicine, you have growing public awareness, and so you see an explosion of psychiatric facilities opening up all across the country. And as more people are being civilly confined, more money is being pumped into these institutions, more of them are being constructed and erected. And you begin to see a large segment of the population being warehoused essentially in these psychiatric facilities. And I've seen this, in my own hometown growing up. I grew up in Brentwood, New York, where literally a section of our town was set aside for Pilgrim State Psychiatric Center, just acres and acres of land. It was almost a town into itself with its own railroad, its own bus stop, its own mechanic shop, because there were so many people being civilly confined in these centers. And you might say, well, it's not abnormal for there to be a large institution if it's the only one of its kind, but that wasn't the case. You walk down 15 minutes and you'll find Kings Park Psychiatric Center, which was just as big and housed just as many individuals. And so, as you can see, there was a bit of a roller coaster ride in terms of where individuals who were mentally ill and maybe exhibited other threatening behaviors, where they were placed. In the early part of this nation's history, they were either in the home or they went to jail because the state, frankly, didn't know what to do with them. Later, in the 19th and mid-20th century, they were very easily put into psychiatric institutions. That was part of the problem, the lax civil commitment standards at the time. The third time period that's relevant here is what we might call the disability rights movement of the 60s and 70s, where there was that, again, a growing awareness that putting money into a system doesn't necessarily mean they're getting the best treatment possible, and that there were a large number of individuals who were civilly confined without any mechanism for assessing that they were receiving due process, either in the initial commitment proceeding or for periodic reviews to ensure that they weren't perpetually kept in a psychiatric facility. So to make a long story very short, what ended up happening is there were a series of Supreme Court cases that came out and lower court cases that redefined the standard for involuntary civil commitment that would apply in all 50 states. And we'll return to some of those cases in a moment. But at present, what you see is essentially a uniform standard all across the United States, although every state has its own specific law for involuntary civil commitment. And in general, what it requires is, one, a showing of mental illness, and two, a showing of dangerousness. And that term dangerousness applies to either danger to yourself or a danger to other people. And so it's important to sort of break that up a little bit, since it relates directly to the topic today in terms of understanding the ethics behind the government's use of power to restrict someone's liberty for the sake of either themselves or for the protection of the greater community. And so with respect to mental illness, that first component, it's really something that's very easy to define. And in the court system, when a police officer or a judge or a medical professional petitions for an individual to be civilly confined, it's almost a foregone conclusion that they're mentally ill. It's not really an intense part of the analysis that ultimately leads one to be civilly confined. Oftentimes they have an extensive history of mental illness, so it's just assumed that they're still suffering from schizophrenia, bipolar disorder, or whatever the case may be. And the courts really just rely on medical expert testimony to say, check off the box, they're suffering from a mental illness. Where the difficulty arises and where a lot of the litigation arises is in trying to determine whether this person is really a danger. And so as I mentioned before, and as one of those Supreme Court cases made clear, and the case is Addington v. Texas, which was decided in 1979, it has to be danger to either yourself or a danger to others. And so there's a couple of different ways of understanding this. I think the simplest way of understanding it is breaking it up in terms of timing and type. So in terms of timing, when courts are considering whether somebody should be civilly confined because they're a danger, it has to be an imminent danger. It has to be an immediate danger, right? We don't civilly confine people because they threatened to kill someone 10 years ago. We may have civilly confined them at the time, but it has to be an immediate or imminent threat of harm. With respect to type, it can be a danger to a person bodily, so physical injury, suicidal thoughts, cutting yourself, that sort of thing, wielding a knife in the middle of Times Square, that sort of thing. It can be a threat to property, right? Someone who is acting in a very bizarre way in the middle of the street may cause an accident, cause not only damage to the person, to individual people who are driving, but also to property. And it can also be psychological, in terms of psychological damage to individuals, because they see, very bizarre behavior. And that might be a little bit more difficult to give an example of, but, for example, if someone is exhibiting bizarre behavior and has what you might consider a weapon, even if they're physically incapable of causing harm because there are no bullets in the gun or it's a plastic knife, they can cause psychological trauma to someone who thinks, oh, they're about to be slit by the throat or to be shot. And so those are the components, and that's how it's sort of understood by the courts when we talk about showing of mental illness and a showing of dangerousness, either to yourself or to other people. And so it bears mentioning that in recent years, there's been a surge of civil commitments, not necessarily under the traditional lens of mental illness and dangerousness. So there was a case, Kansas v. Hendricks, that was decided by the Supreme Court in 1997, which allowed for individuals who were, you might call, persistent sex offenders to be civilly confined. It's the same exact framework conceptually. They have what they call a mental abnormality instead of a mental illness, but the definitions are very similar, and they are a danger in this particular case of engaging in predatory sexual behavior. And so one interesting thing that I observed as I've worked in these spaces is that the populations that are sometimes served, it used to be that a large segment of the population would be somebody who just had bipolar disorder and schizophrenia, or maybe some other traditional mental illness that's more well known. Whereas now a lot of these psychiatric institutions have swelled up because they're housing, in addition to that population, a different group of people who are what we might call persistent sex offenders. So it's a little bit of a different landscape. Moving on into the second section, where the state gets its authority for depriving someone of their liberty. It's an important question. If you're going to deprive me of my liberty, you have to do it right. And if you don't, then I can't be civilly confined against my will. And that's, again, one of the important lessons that came out of the various Supreme Court cases during the 1970s. In particular, I'm thinking of O'Connor v. Donaldson, which was decided in 1975. There's an interesting quote in that case that says, it doesn't matter that the state it doesn't matter that the state has enacted a law. The question is whether it's constitutional, right? So the mere fact that a government, a state, whatever sovereign body makes the decision to put a law in the books to civilly confine someone, that's not enough, right? We need to understand where that authority comes from. And and that same case that I had mentioned before expresses that. In Addington v. Texas, the court makes it very clear. There's only two sources of authority that the government has to deprive someone of their liberty in this way. We're not talking about the criminal context. We're talking about the civil context. The first one is the state acting as parens patria, which is Latin for parent of the country. And so the court explained that when the state acts as a parent of the country, it has the authority to act in the best interest of each individual person within its borders. And so this, as we'll see in a second, corresponds directly to that use of civil commitment where someone is a danger to themselves, right? Because the government, as parens patria, as parent of the country, has the authority to act in the best interest of that individual to prevent them from harming themselves. The second source of authority is the police power that every sovereign nation has. And we've probably heard it in the context of maybe totalitarian regimes, the police state. But the reality is that every nation has the authority to police the individuals residing within their borders. So this police power is exercised as a way of ensuring the protection of members of the community. So the focus here isn't on the individual, it's on the community at large. And so you should see by now how the police power corresponds directly to that second version of civil commitment when an individual is mentally ill and a danger to others. The state has authority under its police power to deprive this individual of their liberty, not for their own sake, not necessarily to make sure they get the best treatment, although that is obviously a legitimate and important concern. But at that stage, it becomes important for the government to exercise its authority for the sake of the entire community, And so our question today is understanding the moral ethics behind the state's use of those two powers, which is used to authorize one of two versions of civil commitment. And so a lot of people get confused because they think of parens patria and police power as giving them the ethical justification, but that's not really the case. Parens patria and police power provide the authorization, but we need to ask the question one level deeper: are those actions ethical, and in what circumstance? And so, in thinking about this issue, there's a couple of ways to approach it. One way to approach it is to assess it from, practical ethics, like a common sense type of approach. Another, maybe more cumbersome approach would be to consider it from a philosophical perspective. And that's what we're going to do in the next few minutes, trying to understand from a philosophical perspective, how can we understand the government's use of its parens patria power and of its police power ethically to ensure that they're doing the morally right thing, right? And so, just to take the first version and start with that. So the first formulation, the first version of civil commitment says that the state, acting in its parens patria capacity, has the authority to civilly confine someone against their will when they have a mental illness and when they're a danger to themselves. And one way of understanding this from an ethical perspective is to look at utilitarianism. So anyone who's taken an introductory course in philosophy should be familiar with the two ethical schools of thought that we're going to talk about today. One being utilitarianism and the other one being Kantian ethics, which we'll get to in a few minutes. So essentially, utilitarianism can be boiled down by the maxim, or by the phrase, the greatest happiness principle, which says that the state acts morally whenever it seeks to maximize the happiness for the most amount of people. And there's a negative version to that, which says the state has an obligation to minimize unhappiness to the maximum amount of people. Kantian ethics is a little bit different. Anyone who knows anything about Kantian ethics is probably familiar with the categorical imperative. And there's 4 versions of the categorical imperative, but the one that we're concerned with is the formula of humanity. And this formula says that the state, and I'm paraphrasing here to make it applicable to our context, that the state is moral in acting when it acts towards a human being as an end in him or herself, and never as a mere means. So actions are ethical. Government actions are ethical when it's done in doing so, it's treating someone as an end in themselves and never as a mere means to an end. And we'll unpack that because I know it's a lot. So let's start with Kantian ethics. Kant says we should treat people as ends in themselves. To treat someone as an end in themselves is to value their choices, value their humanity, value their autonomy, value their goals, value their decisions, to value them as a human being. That's what it means to treat someone as an end in themselves. So when I take my son to soccer practice because he likes soccer and I am dedicating time to that act, I am treating him as an end in himself. If I were to take him to soccer practice because I'm a frustrated soccer player and I was never able to make it to the big time, and I want to live my dreams through him, even though he despises soccer, I'm treating him not as an end in himself. I'm treating him as a mere means, right? A mere means to a different end. So how does this relate to that first formulation of involuntary civil commitment, right? The concept that the government can deprive someone of their liberty when they're mentally ill and a danger to themselves. Well, the government is acting ethically in the sense of using its patria power and caring for that individual in a particular moment in their life when they cannot care for themselves. So in contrast to the other version where you're concerned about other people, when the government is civilly confining someone who's a danger to themselves, they only care about that one individual. And in that context, they are treating that individual as an end in themselves rather than a mere means, rather than a means to an end. So that's a really important concept for anyone who has the authority to civilly confine, for anyone who has the authority to petition for civil commitment, that if you're doing it on the basis of this individual potentially hurting themselves, it's important and it's ethically significant that you value their humanity in making that decision. If you're not doing it for that purpose, then you're not really honoring the humanity of the individual, and the ethical justification for depriving that person of their liberty under that first version of civil confinement kind of collapses on itself. So remember, Kant says that you should never use someone as a mere means to an end. Now, what does that mean? To use someone as a mere means to an end is very different than using someone as an end in itself. There's a difference there. And there's a couple of examples I could give. Probably the most well-known or one of the simplest is a bank transaction. When I go to the bank, I'm using the teller as a means to an end, right? I don't really care about the teller, but I need the teller in order to get my money. The teller, in turn, needs me in order to have a living wage, right? If there were no customers, they wouldn't have a job. So we're each using each other, but we're consenting to that use. So we're using each other as ends, as means to an end. That's different than using someone as a mere means to an end. When you use someone as a mere means to an end, that means you're using them in a way where they can't consent to the action. So, for example, if I ask someone to loan me money and I have no intention of paying them back, but they don't know this, I am forcing them into a situation in which they can't, in principle, consent. And that's using someone as a mere means to an end. And so the question should pop up in your head, well, isn't that what's happening with civil commitment, right? When you're depriving someone of their liberty, they're not consenting to that action. So does the Kantian framework really make sense to justify this from an ethical perspective? And the answer is yes, because when Kant talks about valuing the humanity of someone, the reason why he places such a high value on humanity is because of our capacity for cognitive and rational thought. Compared to animals, compared to inanimate objects, humanity is valuable because of our capacity for rational thought. But what happens when someone is going through a psychological episode in which they are a danger to themselves? In that particular moment, they lack the capacity to make a rational decision, because I don't think it would be disputed that it is not rational to injure yourself for no reason. And so Kant would say, in the moment you choose to civilly confine someone because they're a danger to themselves, you are acting ethically because you're acting how they would act if they had a rational capacity. But because they don't have a rational capacity, you're going to use your patrens patria power as parent of the country to take an action for the better welfare of that individual, with the expectation that with treatment, counseling, and so on, they will eventually graduate, right, to leave that episode and be able to return to society. Now, that's sadly not the case with everyone, but that's the expectation. So you can see how understanding that the overarching theme is valuing the humanity of an individual, you can see how approaching civil commitment from that perspective becomes more morally defensible and ethically justifiable. Now, let me move on to the second formulation. So if you remember, the second formulation says the government can use its police power to civilly confine someone when they're, one, mentally ill, and two, a danger to other people, plural, more than one, so to a community at large. And we had talked about utilitarianism a few minutes ago. And what utilitarianism says is that the government should always act in a way that it maximizes the happiness of the greatest amount of people. And negative utilitarianism just flips that on its head and says you should always act to minimize unhappiness to the greatest amount of people. Now, if you just were to hear that, you would say, well, that sounds a little wrong, right? We're going to deprive someone of their liberty so I can be happy. Well, we have to understand that philosophers don't think the way we think, and they don't use language the way we use language. And so they define happiness in a very particular way. And so Jeremy Bentham and J.S. Mill, they understand happiness as pleasure and the absence of pain. And so viewing it from that perspective, the absence of pain, we can see a direct connection between government using its police power to prevent harm to a community of people. And that's what we're referring to. Those situations where someone indicates that they're planning to bomb a school. Those scenarios where someone is wielding a dangerous object in a high traffic area. Those types of scenarios, the government is authorized under its police power to deprive that individual of their liberty in that particular moment because they demonstrate an imminent, immediate risk of harm to the community at large. And so that's consistent with utilitarianism. And actually, anyone who knows a little bit about utilitarianism knows that it's a political philosophy. So it specifically addresses the government's use of power. That's what it's talking about in the criminal context, in the civil context, in any context. The government has this power to deprive one individual's liberty if doing so maximize happiness to the greatest amount of people or minimizes unhappiness to the greatest amount of people, and defining happiness as pleasure and the prevention of harm to other people. So that's essentially how these frameworks work together, right? That it makes sense. We should never deprive someone of their liberty simply because they are burdensome. We shouldn't deprive people of their liberty because they are unruly, because they're inconvenient, because they're a disturbance, because they're unseemly. Those aren't ethical reasons for depriving someone of their liberty. The only reasons for why we would deprive someone of their liberty is because they are at risk of imminent harm, either to themselves, in their body, in their mind, or in their property, or to the community at large. Again, to those people's bodies, minds, or property. Those are the only two. And so when we understand that from the perspective of Kantian ethics and utilitarianism, it helps inform the way we think about civil commitment. So just to conclude, I think it's worth pointing out, what was the point of this entire presentation, right? It's a lot of philosophy, it's a lot of legalese. And so what's the point for those attending this conference, and how can it be of value to you and your practice area? Well, I don't doubt that many of you are working in these spaces, whether it's as a practitioner, as a therapist, as a caseworker. Maybe you're a person in position of power in law enforcement that has the authority to petition for civil confinement. And I think understanding the ethical foundations for the government's authority in making the decision to civilly confine someone can help make us a little bit more sensitive to what's actually going on in their lives. I think it helps makes us a little bit more sensitive into what they've gone through. Maybe for a caseworker or social worker, it helps to understand whether someone was voluntarily confined versus involuntarily confined because of the different standards that are at play. It also helps us always appreciate and value the humanity of someone when they're being deprived of their liberty. So often these government systems that are in place, they kind of rubber stamp these petitions, especially when it comes to establishing whether someone has a mental illness. It's almost a foregone conclusion, but holding the government accountable to that standard, to that ethical, moral imperative to value someone's humanity, or to ensure we're only doing this because we're protecting the community from an imminent threat of harm. I think that helps us exercise that authority in a more respectable and justifiable way. And the last thing I would say is maybe these ethical justifications don't do it for you. Perhaps these philosophical discussions really don't sound that convincing, and that might be a sign that perhaps it's time to challenge the system. Right? Nothing would have changed if there weren't medical advancements that allow people to see that jail wasn't the answer for individuals with mental illness. And nothing would have changed if advocates didn't come out and say, hey, listen, we need to have mechanisms to ensure that individuals aren't just being rubber stamped into these commitment facilities, and to ensure that there's some due process for a periodic review to make sure they're not forgotten about in those mental institutions, right? And nothing would be done today. In many states, there's a right to counsel in these commitment proceedings. In New York State, it's the Mental Hygiene Legal Service. I know that there are similar names for agencies in other states. That was all accomplished through advocacy, because we want to be ethical in dispensing our responsibility toward every member of our society, which includes those who suffer from mental illnesses and may be a danger either to themselves or to others. So I hope this was an insightful presentation, and I hope that you were able to glean maybe a little bit some newer perspectives on the history of civil commitment, the justifications for civil commitment, the foundations for civil commitment, and I hope it helps you be a better advocate, a better practitioner, a better person in a position of authority to help this segment of our community. Thank you.